The next case is the state of Samples versus LaGrange Nursing and Rehabilitation Center. The appellant will reserve 5 minutes for rebuttal. How long would you like to reserve?
3 minutes, please.
Okay. Just so you both know, there is an appeal and a cross appeal in this case. So during your 15 minutes, you'll need to discuss each. However you decide to break it up, that is up to you. But just understand that you will be getting rebuttal time. You'll have your full 15 minutes, and you'll discuss both appeals during your time.
Sounds great.
The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of any victims or any minors or anything. In this case, I don't know if we'll have that, but please don't do that if that were to be the case. By the way, I will try to let you know when you have about a minute left in your time, each of you, so since I have it up here, there's nothing to do.
Thank you.
You may proceed when you are ready.
May it please the court, my name is William Eady. I represent the plaintiff appellant, the estate of Kester Samples. In this case, as you know from the briefing, the fact finder, the jury, unanimously found punitive damages, specifically endorsing that to a clear and convincing standard, the estate had proved that the defendants, in this case LaGrange Nursing Home and the foundation's parent company and management company, consciously disregarded Kester's rights and safety with a great probability of causing substantial harm. That's already been done. We don't have to agree with that or convince anyone of that today. The only question for the court as it relates to the punitive damages is, was there any evidence from which a juror could reasonably have reached the conclusion that this jury unanimously found? Now, what we see in the briefing from the defense from LaGrange and Foundations is a contra statement of facts and an attempt to paint a different picture, a picture of care that was provided on different days under different circumstances. And it's important to note that under this JNOV standard, it would be inappropriate to consider those facts. Why? Because every fact in this case has to be construed in the plaintiff's favor. The only question is, could a juror, looking at everything in plaintiff's favor, the estate's favor, have possibly reasonably reached their conclusion that the jury did in this case? So when we hear contra facts, when we hear arguments about the facts and what they entail, and the argument that we're cherry picking or misrepresenting the record, if there's evidence that supports punitive damages in this case, the court's obligated to give that all the weight and to disregard contrary evidence, because that's the question. Could a juror, if they chose all the evidence most favorable to the state, have reasonably reached this conclusion? The other thing I think it's important from the briefing that LaGrange Foundation gets wrong and would be misleading to the court is that the court can only consider whether the jury's finding on negligence, and specifically the jury interrogatory they returned saying that breach of the standard of care was failure to timely identify the wound. That for some reason the jury, and thus this court, are restricted in considering that evidence on punitive damages. That's false for several reasons. First of all, Ohio law is clear that punitive damages are not awarded for the incident of injury, but are awarded due to the aggravated circumstances apart from or surrounding the injury or the actions of the party causing the injury. That's the Gibbons case out of the 9th District, this court's decision. So that includes circumstances prior to identification of the wound, that includes circumstances during the care of the wound, and that includes potential cover-ups after the wound, are all fair game and work for the jury. And one thing that I think I lost in the briefing that occurred at trial is the punitive damages phase was bifurcated from the main trial. So when the jurors filled out that interrogatory on negligence, they had not heard the arguments on punitive damages. That had not occurred yet. So the idea that they would be restricted to considering the evidence and arguments that they were thinking of when they filled out the negligence interrogatory is false. Even if the law for some reason permitted that, that wouldn't be the circumstances in this case. And specifically, the defense did not ask for a separate interrogatory on punitive damages. So now they want to, after the fact, come back and say, well, the jury shouldn't have considered this, shouldn't have considered that. We don't know exactly what the jury considered because they didn't ask for an interrogatory. So any evidence that was available to them at trial, and specifically, and this is important I think as well, they did not object during the closing argument during the punitive phase of trial to introduction of all the evidence and arguments that we're making in this briefing. So specifically, the idea of not identifying or reporting the wound for up to 10 days despite having a right to skin checks every shift, every day, was discussed in closing argument on punitives. Again, after the negligence finding, that's on the record at page 1057. Foundation's getting a wound report every week. So this is the management company. Every single week the facility sends a list of all the wounds in the facility, when they were found, what stage they are. As of the earlier wound, if you recall, there's 2 wounds in this case. We saw the claim was for the second wound, but we talked and there was evidence at trial about an earlier wound. Well, what's the significance of that for punitives? Foundations, the parent company, and the facility itself were aware their staff were not performing skin checks. We didn't sue for the earlier wound. We didn't ask for a finding from the jury for the earlier wound. The whole point was they knew, as of that wound being identified in February, already a stage 3 out of 4, that their staff was not doing their job checking this man's skin.
Let me take you just back very briefly to the jury verdict form you mentioned. I will certainly admit that it was lost to me in the brief as well, and you described to me was not for the punitive, just for the initial trial. Was this something that you argued the trial court below as well, as that we should not give weight to that jury verdict because it was only for the initial and not the punitive damage?
Great question. Not only did they not object to the argument of that evidence before the jury, that was all briefed below to the trial court. All of these bases for punitive damages was part of that record. And importantly, you can disregard the trial court's findings altogether. This is de novo review of the JNOV. So your question is based on what the jury heard, and it included things, not only the wound report, but the wound vac failure and the argument of false charting, that they either didn't violate the order by Xing it out and acting like it wasn't an active order when it was, or check marking when the wound vac worked for 10 minutes that day and then immediately failed. That was argued, that's on the record at page 1060 to 61. Again, no objection made to using that as evidence in support of punitive damages at the time of trial, nor would the jury be limited to what I argued on closing argument. They're entitled to consider anything during the course of the trial that was admitted as evidence of conscious disregard. And importantly, we know that taking the facts in the light most favorable to the estate, the staff who were supposed to be looking at this man's skin, including the bony prominence of the tailbone area where the second wound occurred, were supposed to check it every shift, every day, particularly vigilant after the earlier wound wasn't discovered in a timely way, and they didn't do that for 10 days. We heard testimony about 5 to 7 days, 7 to 10 days, construing in the light most favorable to the estate. 10 days. While this wound grew from a stage 1 red area to an open stage 2 to an open stage 3, to the point where it was oozing foul-smelling discharge. It was covered in part with crusty, dead necrotic tissue. It was infected. The inescapable conclusion is the staff did see it and didn't do anything about it, consciously disregarded his right to care, or the staff consciously disregarded his rights to those skin checks. And this isn't, a decision here upholding the unanimous verdict would not begin to change the landscape in these cases. This is not, well, we didn't see the wound fast enough, or we made an honest mistake and didn't treat it the right way, or any one of these things. This is 10 days of ignoring the wound until it's 9 by 8 centimeters. Stage 4 is all the way through the skin, through the fatty tissue, to the point where you're exposing bone or ligament. They're changing this man, they're dressing this man, they're taking him to the bathroom. There's testimony the jury heard, this is on the record, trial transcript, page 795 and page 830, that in fact had a bowel movement 2 days before they finally identified the wound and reported it, and they had to have seen it at that point. So that is evidence a reasonable juror could conclude that they had in fact seen this wound and for 2 more days failed to provide any care or treatment whatsoever. In the state this man is in when they finally identify the wound and get him care, he is already septic, his organs are shutting down from infection, the wound is infected, it's draining purulent discharge, it is large and grotesque and has already become necrotic. He is literally dying, and that is the first time they do anything about it. So this is not a standard, we're not just coming and saying, gee, they let a wound develop in a man in a nursing home. They did that once, they blew it, they knew they blew it, they were on notice that they blew it, the parent company is on notice that they blew it, and the very next month, nobody's doing the skin checks, or, and I say, you should conclude, based on the evidence looked at the light most favorable to the state, they did in fact see it. and chose to do nothing for 2 more days until the man was literally on death's door. I want to touch briefly on the false charting. Again, absolutely can be considered, was argued to the jury. The Demora case is very instructive on this case. That was a case where someone fell. It was negligence, broke some ribs, and a doctor wrote in a progress note that everything was A-okay. It was after the fact, so it wasn't related to the initial incident. And the court found that it was appropriate to send to the jury for punitive damages, and they note, this is at page 720 to 721 of the decision, that the evidence has shown that Mrs. Demora had fallen and broken 5 or 6 ribs, yet upon examination the doctor noted she was smiling and laughing, pleasantly with no pain upon deep palpation of the area. Other testimony indicated that she was in pain and crying. Such discrepancy between the written progress notes and the testimony of the witnesses who observed Mrs. Demora is evidence sufficient to raise a question of fact as to the possible falsification of documents by the physician to minimize the nature of the incident and the injury of the patient due to possible negligence of the hospital personnel. So, same situation here when we see the wound charting and they're pretending like there isn't an order when they exit, or they pretend they followed it when they do a check mark, as well as that unavoidability checklist. So there's a form prepared by the parent company that says, hey, check the boxes and we'll decide if this wound was unavoidable, which is a term of art, protects them from liability, make sure they get paid for the care from Medicare. And they check boxes, and this is on the record at length, transcript page 810 to 817. We showed this to the jury, we put it up on the screen, we asked their witness about it, and there are consistent false check marks on that form. That they were checking bony prominences every shift, every day. We know that's not true. That they did provide all the assistance, slip sheet, draw sheet discussion in the briefing. They weren't doing that, even though there's a sign on the wall the family made them put up to say, make sure you're using this. That's conscious disregard.
1 minute left, Counsel.
Thank you. And then briefly on the litigation expenses, there's no case that anyone has cited or can find in the state of Ohio that says fees awarded in punitive damages are limited, the expenses are limited to Rule 54D. And I want to draw your attention to the Cruz v. English nanny case, because in that case, the Supreme Court of Ohio indicates that pursuant to the same interrogatory we use, standard OJI language, that when you say attorney fees, you can get reasonable case expenses, and in that case they were awarded over $30,000, not court costs. That's the Supreme Court of Ohio and the Ohio Jury Instructions common form. None of them say you have to have a separate line for attorney expenses. That's made up from whole cloth. Thank you.
Thank you.
May it please the court, my name is Elizabeth Argo and I'm here today on behalf of LaGrange. Your Honors, I would like to just circle back to what the issue is here, and that is whether or not the trial court properly granted judgment notwithstanding the verdict on the issue of punitive damages. And the standard there is whether or not there was sufficient, clear, and convincing evidence that LaGrange acted with actual malice. Now, as we've heard extensively, the focus of these arguments was actual malice, and actual malice can obviously be proven by conscious disregard for the known rights and safeties of others when there is a great probability of harm. We believe that the trial court correctly made the decision that there was not sufficient evidence. The standard is not was there any evidence. The standard is whether or not there is sufficient, clear, and convincing evidence that LaGrange acted with a conscious disregard. Now, we've heard a lot about whether or not the trial court was permitted to consider events that happened before and the other. LaGrange is not arguing that those can't be considered. What we are saying is that the jury was presented with the totality of these circumstances. The jury heard this evidence, and when they were asked on their interrogatory what the breach of the standard of care was, they identified one thing, and that was that the LaGrange failed to timely identify the March pressure ulcer. And so what we are saying is when the jury heard that evidence, they didn't identify anything else, any other wound, or any other conduct that they said rose to the level of negligence, let alone a conscious disregard. And so also, I want to touch briefly on the February, the other pressure ulcer. That was identified, treated, and healed completely. And so there is nothing that we've seen from the estate at all, or any case law that says that identifying a wound, treating that wound, and healing that wound can be the basis of showing that a defendant consciously disregarded another risk just because another pressure ulcer developed. Now, Mr. Samples had a complicated medical history, and he was diagnosed with Alzheimer's. And so when you're looking at the conscious disregard, care was extensive from, well, he became a permanent resident, I believe, in 2014, but what we're talking about here is from December 2015 to May of 2016. And so to Mr. Eadie's point, we are looking at the totality of these circumstances. And what LaGrange did was, as soon as he was diagnosed with a UTI in December of 2015, his health began to deteriorate. And so they LaGrange put into place multiple care plans. That included a skin breakdown plan, a nutrition plan, a fall plan. They met with the family members to discuss treatment on how to go about his nutrition, how to keep his caloric intake, because all of the witnesses agreed that that's important to the wound care. They had a wound care plan in place that they implemented and then used in February that resulted in the successful treatment. And so what we've seen when we're talking about conscious disregard, what this court said in Gibbons and what the Ohio Supreme Court has said, is that conscious disregard is judged against the backdrop of the purpose of punitive damages. And the purpose of punitive damages is to punish and deter. It is not to compensate. And so against that backdrop, there has to be a positive act of wrongful conduct. They describe the misconduct that they're looking at as being criminal, flagrant, and intentional. And when you're looking at conscious disregard, as this court said in Gibbons, recklessness and negligence is not enough. And that is what we've seen time and time again in the cases. We saw that in the Estate versus Schmidt case out of the 10th district. We also saw that by the 8th district in Lang, where they found that they looked at the attendant circumstances and found that this may have been negligence, but this does not rise to the level of something being a conscious disregard. It is a subjective intent, and you are looking at what the defendant had, what their motives were, and we have no evidence here that LaGrange acted with a subjective intent to cause or consciously disregard Mr. Samples' health or safety when they were identifying this. Now, we acknowledge that the jury found that they were negligent, and so we recognize that, but it is important to recognize what we are talking about, and that is conscious disregard, and it's looking at the totality of the circumstances. Now, we've also heard, I want to touch briefly, so we've also heard a lot about the 10 days and things of that nature, and what we would say is that this court, first of all, the 10 days is a bit of, there was evidence in the record. I understand what Mr. Eadie is saying, is that there's some evidence going one way or the other, but the point is that there was multiple witnesses that testified that these pressure wounds could appear overnight, that they could have appeared at different times, and so the jury did find and acknowledge that they found that this was a failure to diagnose the pressure ulcer in a timely manner. But there is no evidence showing that they consciously disregarded Mr. Kester's safety and health when they were treating him. And so we would say that the trial court correctly looked at that and found that this may have been negligence and it may have been carelessness, but it was not a conscious disregard by any single actor of the rights and safety of Mr. Samples. And then the false charting, I do want to talk about that. We recognize that Moskovitz has said that false charting can be evidence of actual malice, but there is no evidence of false charting, as the trial court correctly pointed out in their opinion. They did not bring up this checklist at the trial court level. They did not argue that the checklist was the basis for false charting. The false charting argument that they made in the trial court was related to the wound vac, and when the order for the wound vac was put into place, they so first, with regards to the wound vac, as the trial court correctly pointed out, there is no evidence of false charting. Rather, what the progress notes say is that the LaGrange did identify that the wound vac was not working. They called the physician. The physician gave them an alternative plan of treatment, and they implemented that. And so to say that that is conscious disregard to follow a physician order or actual malice just does not hold water. There's no case law that would support that standard. Regarding the checklist, these questions were posed in the form of hypothetical questions. There is no direct evidence, as is recognized in their reply brief, that there was a falsification in the checklist at all. This checklist is used for billing purposes, and it was not, there was testimony stating they were posed in the form of if-then statements and hypothetical questions. And so we do not believe that there's any evidence that those were falsified, but even so, anytime there is an alleged falsification of a record, there has to be also a tie to it saying that there's an avoidance of liability, so that it was done for the purposes of avoiding liability. And there was no evidence put forward that this was meant to avoid liability of any kind. And so even if they properly preserved the checklist, which we disagree, it is not evidence of actual malice, and there is no evidence of false charting. Rather, what we have here is LaGrange made a conscious effort to develop a care plan for Mr. Samples, who was at risk of pressure ulcers, and that's why he had a skin breakdown plan. That's why they had a very detailed nutrition plan put into place. And that resulted in identifying a pressure ulcer, treating that pressure ulcer in February, and then we acknowledged that there was a delay in identifying the March, but the jury found that that was the basis for a survivorship claim, but that did not cause his death. And so we would say that the trial court correctly looked at the totality of these circumstances and found that there was a lack of sufficient clear and convincing evidence that LaGrange acted with a conscious disregard. I also want to touch on the litigation expenses. Now, we would say that the litigation expenses did need to be a separate line on the jury form in order to be awarded. We do not think the trial court erred in not awarding these litigation expenses. The estate cites some cases that say that these miscellaneous expenses are part of an attorney fee award, but we would say that what CRUIS and stands for the proposition is that these are damages that the jury needs to decide that you are entitled to. They are meant to compensate in some way for the recovery, and so if you're going to also give a separate line, so this is not something that factors into attorney's fees, they've asked for a separate award for just these litigation expenses, that needs to be put to the jury, and because it was not, that they should not be awarded, but also that the requests were unreasonable. There were multiple requests for exorbitant litigation expenses that weren't properly documented, and so we believe that that's all outlined in the briefing. And then the last, which you want to touch on the final assignment of errors, that we would say the trial court properly applied the non-economic damage cap. The estate did not raise the issue prior to the jury being charged. Whether or not the caps have been exceeded, it is a factual question for the jury to determine that cannot be posed to the jury in a separate interrogatory or after the jury has officially been charged. So we would respectfully request that this court affirm the trial court's decision. And I can touch on our cross appeal, but I think we're okay resting on our.
You have 5 minutes left if you wish.
Oh, I do?
You're welcome to.
Okay. All right, well, I will touch on the attorney's fees. So if this court was to get to the issue, we don't think this court even needs to get there because we think that the judgment notwithstanding the verdict should be affirmed. But if the attorney fee issue is considered, we believe that the trial court did abuse its discretion. That is for a couple of reasons. The trial court used a $250 hourly rate, but applied that not just to attorneys, to paralegals and paralegal assistants. And I think there's no dispute that if you're going to award attorney's fees for paralegal hours, they have to be done at a lower rate. And so we have nearly 500 hours of paralegal assistant and paralegal hours that were given at a $250 rate, which we believe is an abuse of discretion. In addition, there were hundreds of hours in the attorney's fees that had no documentation. They did provide a task code, but there was no narration to describe. And so under Phoenix and the Lodestar, there is a presumption that reasonable attorney fees, or reasonable hours times reasonable rate is reasonable. But that calculation, the base calculation has to be there. And so what we would say is you can't determine that the hours are reasonable if there's no narration and there's nothing to describe what has been done. And so we would say that the trial court did abuse its discretion in awarding those fees in the way that they did. So if this court was to reverse, we would ask that you find there's an abuse of discretion on the attorney's fees. Any questions?
Thank you.
Briefly, I think we've heard the exact problem, the same mistake the trial court made, relitigating the facts. The Supreme Court of Ohio is very clear that on a JNOV standard, this is the Osler case, the evidence adduced at trial and the facts established by admissions and pleadings in the record must be construed most strongly in favor of the party against whom the motion is made. And in fact, they characterize these motions as, quote, a favorable ruling on such a motion is not easily obtained. There's a reason for that. You're taking away from the fact finder. You're essentially saying 8 jurors were all unanimously unreasonable because there's no evidence from which any of them could have reached the conclusion that they disregarded Kester samples' rights and safety. And importantly, the Supreme Court in Osler goes on to say, neither the weight of the evidence, so everything you heard about disagreeing with the particulars of the evidence or how it's interpreted, nor the credibility of the witnesses is for the court's determination in ruling upon either of the above motions. Directed verdict or JNOV. So what did we hear? Reference to the trial court disregarding evidence and construing evidence and weighing evidence below. That's what they're asking you to do here. It was improper at the trial court level. It's just as improper at the appellate court level. We put up at trial a checklist that they filled out that said they checked the bony prominences every shift. They checked the box. That's false. That's after the fact false charting. We don't have to argue at that point. We have to construe that in our favor. The same is true. They said there's nothing about the February wound being a problem. They claim they identified it and treated it. Actually, there was a significant testimony at trial, including from their expert witness, Dr. Garcia, a wound expert, where she agreed there's no excuse for finding a wound when it's already stage 3. That means they weren't doing their job. That testimony was played at trial. So having arguments about care they provided years ago and any of that doesn't matter, as long as there's evidence construed in the estate's favor that supports the finding that the jury unanimously reached. And just briefly on the separate line item for expenses on the verdict form for punitives, the Ohio jury instructions, the pattern jury instructions don't have that. They have cited no case that says you have to have that. And the Cruz case, specifically, this is the Ohio Supreme Court, says the jury returned a verdict to include case expenses. I'm sorry, attorney fees. Did not have a separate line for expenses. Misspoke there. And the court went on to explain during that case that included an additional $30,000 in expenses. Now this was when they went ahead and issued the ruling that said we'll also get our fees and expenses from defending the verdict on appeal. But in that context, they review the history of the case and say, jury checked the same box that is in OGI, that's in the jury instruction they agreed with, that was returned in this case, attorney fees, and as a result of that, it was absolutely appropriate to get, in that case, over $30,000 in expenses, and why not? The whole point is they shouldn't have to pay to litigate the case when they recover punitive damages, and they will have to pay those expenses back. When we go to the probate court, the probate court will say that we're reasonable, and they will have to pay the law firm, and they shouldn't have to.
Thank you. Your time is up. You may briefly conclude.
Thank you.
The court will take the matter under advisement, issue a decision in due course. When that decision is released, the clerk of court will mail a copy to you. It can also be available on the Ohio Supreme Court website. I want to thank you both for